Good morning.
Good morning. May it please the court, my name is William Saltzman. I represent the defendants. For nearly 30 years, it has been settled law that corrections officials are entitled to place and hold prisoners on temporary awaiting action confinement for a reasonable period for such purposes as awaiting a disciplinary hearing, awaiting a classification, awaiting a transfer from facility to facility, awaiting out-of-state placement, and awaiting an investigation.
How do we know in this case that, in fact, that they were doing it for those reasons?
Mr. LaChance was given notice each time. The record is not disputed in this case.
But notice of what?
He was given notice of the purpose for which he was placed on awaiting action. The case began when he committed disciplinary offenses in the protective custody unit at Sousa Baranowski, which is a maximum security correctional facility. He awaited discipline. He committed another disciplinary offense while he was in the unit. He awaited the appellate period, and then he was placed on awaiting action.
And during the 10-month period that he was held, was there any effort made to either find another institution for him to be located to?
Mr. LaChance's placement was a difficult matter. He was both a maximum security inmate, which limited his placement within the Department of Correction, and he had protective custody needs.
And does the record disclose what efforts were made to relocate him?
Yes, the record does. The first effort was to consider classification within the Department of Correction. There was a classification hearing. The board recommended lower security. The superintendent disagreed, and the commissioner, in her discretion, rejected that. Following that,
Rejected the lower classification?
Yes, yes. Following that, there was a referral for out-of-state placement. There is an affidavit from Roland Ralt, who was then the county and interstate manager for the Department of Correction, and he detailed the problems that the department was faced with trying to get Mr. LaChance's alternative placement. Placing an inmate in another corrections system is pretty much like fishing. You put the bait on the hook, you put the hook on the water, and you hope another system is going to come up with a trade who's going to be suitable for placement in the Department of Correction.
So you're saying this is a totally passive exercise? You don't contact other systems and say, we have someone we'd like to trade?
No, the record doesn't indicate what affirmative efforts were made, but it does indicate that Mr. LaChance had previously been placed in New Hampshire, that he did everything in his effort to undo that placement, and that he was an extraordinarily difficult placement for the Department of Correction.
So when you say he was referred for out-of-state placement, I don't understand what that means. I mean, put on waivers, and was there some information out there that you were interested in moving him that was conveyed to anyone?
The record doesn't indicate what was done by the county and interstate office. The record indicates that he was referred to that office for them to find and identify a placement out of state. We maintain that the 8-month period, the portion of the awaiting action in which he was on awaiting action status, was certainly reasonable given the placement difficulties.
Why wouldn't a 2 or 3 year period be also reasonable? But just no one has agreed to take him, or no one has contacted us saying they're interested in taking him. How long can that period go?
I think it's very difficult to assess prospectively how long would be reasonable given the difficulty in the case. The important thing is that there were other options that the department was considering, and as soon as the other inmate with whom Mr. LaChance had the serious issue left the unit, the department was able to place him back in the unit. So it wasn't that he was left there and they threw away the key. There was an affirmative effort to find appropriate placement within or without the facility.
And so was there an affirmative effort, I can't recall now, I'm just sort of blanking on this, to move the other inmate with whom the inmate had a problem out? Or did that just was that happenstance?
There is nothing in the record to indicate the reasons that Mr. Evitchi, the other inmate, left the unit. The record does indicate that there is only one maximum security protective custody unit. It's operated in 2 phases, which provides some ability to separate inmates from each other. But it's a very difficult unit to run because every inmate there is not only a maximum security inmate and therefore a predator, but also a potential victim. the superintendent was very much concerned, given Mr. LaChance's long history of extraordinarily manipulative behavior, that what was going on between him and this other inmate had the potential to cause extraordinary disruption.
I guess I certainly recognize that this is a very difficult problem. That's without question. But I'm just wondering, how long can he be held in sort of this area of suspended segregation and without a hearing? Well, you say he doesn't get a hearing, he gets updates?
Well, here's the problem below, is that the Superior Court looked at this as a Haverty case, not as a Hewitt case. The Superior Court looked at the fact, well, in Haverty, this court said there are really two things to determine whether a person is in a DSU. One, the conditions of confinement, and we're not quibbling about the conditions of confinement. Two, the indefinite nature of confinement. The lower court looked at the fact that there wasn't an end date to this and said, aha, this is a DSU, it fits the Haverty test. But that is incorrect as a matter of law, because we can hold inmates like Mr. LaChance in restricted confinement for a reasonable period, and reasonableness is obviously something that's going to be determined on a case-by-case basis. By failing to make the reasonableness determination, all of the other constitutional errors flowed, including the denial of qualified immunity to the defendants.
Well, could he have been put in a DSU confinement, under DSU confinement, for the problems that he had been creating for the system? And if the answer to that is yes, how long could he have been committed to a DSU unit?
The answer is interesting. The answer is that he remained classified as a maximum security general population inmate. In the traditional DSU situation, it's determined that the inmate cannot continue to exist in general population. He needs to be in restrictive confinement, and that's his classification. Mr. LaChance was always maximum security general population. The problem is we didn't have a general population place to put him. That made awaiting action status appropriate pending a determination of another placement, as opposed to DSU status. The department does not, and was not at the time, operating a classification-based restrictive housing unit, which is essentially what DSU is, as opposed to a temporary awaiting action segregation unit or long-term disciplinary segregation unit like the
But
DDUs.
when you call something temporary, I mean, labeling it doesn't make it so. I mean, how long? I mean, you can keep saying it's temporary because we don't have a place to put him, but that doesn't exactly take into account what's happening to him.
No, it's temporary, but it's also reasonable. The error below is there was no determination as to reasonableness. We submit that given the facts and circumstances, given the difficulty in placement, given the fact that Mr. LaChance had essentially painted us into the corner by making it impossible for us to keep him at the maximum of security protective custody unit, the department needed to take him out of population on a temporary basis and try to find some other place to put him. You know,
I take it that if he hadn't been in protective security, you say he's classified or was a general population inmate, you
That's
could have
correct.
put him back in the general population.
That's correct, but I doubt
both
he-
classifications.
He was protective custody. We couldn't have put him in general population at Sousa Baranowski. It's doubtful he would have gone. You know, the notion of inherent in the DSU regulations of a conditional release date becomes essentially meaningless when you ask the question, well, conditional release to where? He couldn't be released to general population because he's protective custody. He couldn't be released to the one and only protective custody unit because of the very serious issues going on. What happened below is that by failing to apply the reasonableness test in the first instance, the lower court essentially overruled Hewitt, which says that we can hold inmates for a reasonable period and the only process due is the informal reviews. It overruled Sandin, which says that due process doesn't attach unless there's an atypical and significant deprivation, and it created a situation in which one prisoner in awaiting action who might have a predetermined date, for example, a disciplinary hearing 2 weeks from next Thursday, would be entitled to only the informal Hewitt reviews, and another prisoner who might be subject of an investigation or for whom the department is seeking out-of-state placement would be subject to the 421.
So then you're saying, and I'm not playing the devil's advocate. What I think I hear you saying is, for some people, a reasonable period of time could be the rest of their life.
We would hope not. We would certainly hope not. And in this case, the department made efforts to find a placement. We don't want to leave somebody in awaiting action forever. He presented an extraordinarily difficult case. It is really in the spectrum of kinds of problems. You deal with an outlier.
But help us out with the way we think about these kinds of issues. When does a reasonable time become forever?
Well, it would have to be, in this case, far longer than he was kept there. 3 months and then the 8 months for out-of-state placement is certainly reasonable given the facts and circumstances and the difficulty in placing Mr. LaChance. Even if this court would look at the record and think, well, the Department of Correction could have, should have, would have done it different, we're entitled to qualified immunity under Saucier v. Katz's reasonable but mistaken belief determination. My clients thought it was reasonable to hold him there, consistent with Hewitt, consistent with the, given the facts of the situation. If we were wrong in making a prediction, that is extraordinarily difficult to make as to what would constitute reasonable. It's still a reasonable but mistaken determination.
The DSU regulations, and you concede that the conditions are equivalent to DSU, do you not?
Oh, conditions are substantially equivalent for segregation, for disciplinary confinement, in the DDU, for awaiting action confinement, which is governed by 423, and in a classification-based housing, which is the DSU.
Now, the DSU regs say you can hold somebody in awaiting action for only 15 days and 30 days if there's to be a disciplinary hearing. Why is that? Why would the commissioner state that if that is an unreasonably short period of time?
Okay. Your Honor, you're referring to 421.08, which is cited by the other side. Subsection 2 says placement on awaiting action and restrictive confinement may never be a substitute for placement in the DSU. And subsection 3 has the 15-day provision, but they follow subsection 1, which refers to placement of a person in DSU. This was never placement in DSU in the first instance.
And it was placement in conditions equivalent to DSU, and why does Haverty not kick in then?
Okay. The process that's due, assuming a liberty interest, depends not only on the nature of the confinement and the duration, but also on the purpose. The hypothesis that 421 applies to this type of confinement simply because the conditions are the same can be tested and rejected simply by looking at the other decisions concerning procedural due process attendant to segregation. In Torres, this court considered long-term segregation pursuant to the disciplinary process. In that case, the court said we need not find whether there's a liberty interest. In other words, if he goes to the DDU for 30 days versus 10 years, but the processes in the disciplinary regulations are sufficient. In other words, the inmate gets his Wolf hearing up front. He's good to go for 10 years. Awaiting action confinement, the informal reviews are the process that's due. The purpose is to make sure he doesn't get lost in the works.
Right,
and in this case,
but the bottom line is he's still in shackles. He's still in solitary. Why does he not get the same due process hearing that somebody gets who is in DSU? As far as he's concerned, his conditions are exactly the same, and the period of time here is 10 months. So why is he not entitled to some hearing as to whether those, as to whether solitary is appropriate for him?
It's not constitutionally required then to provide more than informal reviews during the period of awaiting action confinement. Secondly, even if the court were to determine that he was in a DSU, 421 is not constitutionally required either by the federal constitution or the Massachusetts Constitution. If we never had a DSU, if there had been no Hoffer, no Haverty, no Gilchrist case, and the commissioner went to establish one today, and the question were asked, what process is required? We would be looking at Wilkinson v. Austin, which specifically rejected many of the enhanced procedures that were required in the Hoffer case in 421.
Then how did this court, through a single justice affirmed by Haverty, prohibit DOC from abandoning its DSU regulations when it wanted to. It wanted to withdraw them, and this court said, no, you can't.
Haverty was decided as a regulatory basis. The department has to
Based on the
follow
regulations which the single justice refused to permit you to withdraw. How could he have done that if it were not constitutional?
Well, if we look at Wilkinson v. Austin, it's more than the Constitution requires. Under the state constitution, this court has said time after time that the Massachusetts due process provisions are coextensive but do not exceed.
Okay, but Justice Liakos relied on the Massachusetts Constitution in Hoffer v. Fair, did he not?
That's correct, but that has never been mainstream. That was a single justice exercising original jurisdiction as a trial court. Yes, we've been enjoined to use these regulations, but that's been in cases in which we used long-term segregation as a housing placement. That's Haverty, that's Gilchrist. In all the other cases I cited where inmates claimed entitlement to 421, where they're held in awaiting action, courts have rejected that. The application of 421, and have gone with Hewitt and Puckett and Royce. Due process depends on
Puckett says there's a rule of reason.
And a reason. And the fundamental error that set the Superior Court on the wrong direction is that it failed to make that determination. I would hope that this court would decide this. It is qualified immunity, which is a question of law. It need not go back to the lower court. Discovery was completed. There are no disputed facts on the record, and it is purely a question of law. And I submit we are entitled to qualified immunity because it's not clearly established that 421 applies when an inmate is on awaiting action in a Hewitt situation. And I think my time is up. Thank you.
May it please the court, I'm Bonnie Tenoriello for the plaintiff Edmund LaChance. Mr. LaChance is seeking damages for being held 10 months in a small concrete cell, 23 hours a day, get your food through the door of the cell, 1 hour a day, 5 days a week in a small outdoor cage.
Well, what do you think
that's
that
it.
the Commissioner of Corrections should have done for Mr. LaChance?
The commissioner could have kept Mr. LaChance in segregation following the letter of the DSU regulations. The DSU regulations merely require that these allegations that he posed a threat in population, it's worth mentioning what he did was throw a cup of pudding at a prisoner and make
That can be very explosive.
Yes.
That's not fair to quite characterize it
It's-
that way. This is not a school cafeteria.
Correct. Assuming that there was a substantial threat, and all the department would have been required to do was to convene a board and let the board say, yes, Mr. LaChance poses a threat. He's not getting out of segregation until we decide he's met the conditions. There is no more threat. Maybe the condition might be, maybe the DSU board might say, we're going to keep him in segregation until another state takes him, or anger management classes, whatever. The DSU board, and any end of a DSU sentence is made conditional by the regulations on compliance with these conditions. If the conditions are not complied with, DSU board is free to again decide to keep the prisoner in segregation. There's no way that the DSU regulations do not put the department in the position of having to release any dangerous prisoner or any prisoner who poses a severe management problem in general population to the population. It just requires that they demonstrate that this threat they claim is substantial and real. Mr. LaChance never got that. And it also requires that they give the prisoner some notice of what they can do to earn their way out, some incentive to change. Mr. LaChance never got that. Neither he nor any prison administrator knew when he was getting out of that small segregation cell.
How could he have earned his way out? You can't place him back in protective custody. You can't place him in the general population. You're looking for how does he earn his way out? This is not a question of earning one's way out, is it?
Well, assuming that a prisoner is never going to be safe, I guess the the purpose of the DSU regulations is to ensure that nobody is held in segregation forever
And isn't that what
without
these
any
periodic,
process.
what do these periodic reviews do? I guess it was every week or so he got a review?
No, a sentence can be up to 6 months. In the
No, I'm talking about the periodic reviews
that he was
received.
given.
He was given. What do they
Just a
consist of?
notice. You're being held in segregation, awaiting out-of-state placement or awaiting classification.
The
That's
same notice week in, week out, no personal appearance, no ability
absolutely
to
no due
respond to
process.
anything.
No adversarial process, not even a notice of the reason why he was thought to pose a threat, certainly no opportunity to contest it, and no way to earn his way out or to provide any end date.
Now,
And
how soon do you say that hearing must be held, and is that based on Constitution or regulation?
The regulations say you may only hold someone in conditions equivalent to a DSU in restrictive confinement for 15 days, or if they are waiting a disciplinary hearing, 30 days.
That's the awaiting action regulations.
That's the awaiting action provisions of the DSU regulations. Now, they do allow the commissioner in writing to certify that they need longer than 15 or 30 days, which did not happen in this case, in extraordinary circumstances. And I should say, you know, the department here has raised cases allowing waiting action in segregation for a reasonable period of time. His reasonableness standard was because the department repeatedly, time and again, was told you can't just leave someone in waiting action in segregation as a means to avoid giving this DSU process. You can't just call it a waiting action and then never give them DSU process. These cases imposed a reasonableness standard. Then Hoffer came along, and with Hoffer, the new DSU regulations, precisely because the department had been keeping people repeatedly for indefinite periods of time, Hoffer put a time limit. The regulations drafted under Hoffer said 15 days, 30 days. That's it, unless there's really extraordinary circumstances. And if the circumstances were so extraordinary in this case, the commissioner could have certainly have certified and kept him in longer than 30 days awaiting action.
As a general matter, is throwing a container of pudding at an inmate in a cafeteria the kind of conduct that typically results in a DSU proceeding?
I can't speak to that, and I think the department would be free to argue that this conduct was dangerous and that Mr. LaChance was unmanageable in the general population. I think that certainly was their prerogative, and I certainly don't have the means to make that judgment call, but the point is they never did test this. And to say that prisoners in awaiting action status are not covered by the DSU regulations, again, a central argument that the department is making here, any prisoner on awaiting action status in segregation is there because he is thought to pose some sort of threat in population. Otherwise, you await action in your cell block, in your regular unit.
So are we to say that 423, I get a little confused by the numbers here, 423 that deals with this case, right?
423 are the segregation regulations, not the DSU regulations.
Right.
The
There's a
special management.
And
Yes.
isn't that what the department is saying? He's held under 423?
The department chose to label his confinement awaiting action. They chose to say that he was being given the benefit of the 423 procedures. The 423 are precisely what I was saying before. They only get a notice. You get a once a week. They say, we're holding you waiting out of state. None of the process.
So you're saying 423 actually is inconsistent with Haverty?
It does not provide the process that the DSU regulations provide.
Is that before us now, or are we only dealing with the qualified immunity question on
Well,
appeal
I
here?
think that in this case, there is,
On this appeal, I'm confused.
Well,
I know what's in the, I mean, the case is larger, but is the appeal more narrow?
the appeal is on qualified immunity, but I think Really, if you look at the two prongs of qualified immunity, there was absolutely no reasonable mistake of fact or law. It's a question of do the regulations apply or not. In Haverty, and time again in the Kenny, Puckett, Royce, Gilchrist, Martino, the court has said you can't use awaiting action status as a way of avoiding the DSU regulations, and you can't use the label of a unit. You cannot use the label of a unit as a way to avoid the regulations. No matter what you label the unit, if it looks like a DSU and smells like a DSU,
So purpose,
DSU.
so purpose is
And this-
it's just a question of the conditions of confinement. Purpose has nothing to do with analyzing whether it's a
yes,
DSU matter.
Actually, Haverty explicitly says the purpose does not matter. Haverty said that the DSU regulations are applicable to all placements of prisoners in segregated confinement for non-disciplinary reasons, as Mr. LaChance was, not serving a disciplinary sentence for indefinite period of time.
but
all unqualified. And cases before Haverty made clear that you could be held in the Concord administrative segregation unit, as was the case in Longval. They didn't call it a DSU, and they said the department may not step statutory and regulatory provisions in the DSU regulations by assigning as a pretext another name to such a unit.
Okay, but Haverty did not deal with what was meant to be indefinite. I mean, the problem with awaiting action is they're doing things to get rid of him, and they don't know how long that's going to take. So how long do they get to do that before you say they have to go through the process of a hearing where you have to give notice, an opportunity for counsel, bring in witnesses? I mean, it seems the 15 days would mean you'd have to start basically at day one, wouldn't you?
There are two separate issues here. How long it takes to find an out-of-state placement and how long it takes to determine whether he poses a threat in population. Now, lots of prisoners awaiting out-of-state placement for months could be held in general population. You're only in segregation if you pose a threat. You don't have to finish the out-of-state placement to determine does the prisoner pose a threat. If he does, under the DSU regulations, 6 months, after 6 months, you review it, still poses a threat, 6 more months. Meanwhile, you're seeking out-of-state placement. But that decision as to whether the prisoner poses a threat is entirely separate from whether these administrative procedures will be completed or when.
But pragmatically, doesn't that mean that you essentially have to begin the process of providing for a hearing at day one of awaiting action status in order to make sure you have a hearing by day 14?
This is what the regulations require, and certainly if there is an extraordinary case, exceptions can be made to the 15-30 day. But yes, this has been the law for.
So you say the law. The 14 is, I know, part of the DSU regulations. Is it your view that the 14-day is a constitutional requirement?
The 15 days.
15 days.
Yes, Your Honor. The Hoffer regulations, the Hoffer decision required these regulations as a matter of constitutional law, and the Haverty decision, which was post-Sandin, reaffirmed the constitutional nature of the violations. Indeed, and as was mentioned before, as I believe you yourself, Your Honor, mentioned, Haverty said it's constitutional. If you want to repeal it, go seek relief from Hoffer. In Longval, this court held.
That's basically the law of the case. I mean, that's what that language means, doesn't it?
Well, I think
the department never tried to reopen Hoffer.
And the reason why it's law of the case is precisely because it's a constitutional requirement. But even
That's sort of circular, isn't it?
Well, Haverty also, Your Honor, Haverty independently affirms in many places that this is a constitutional requirement. And indeed in Longval, the court itself at Longvale assumed that damages were available absent this close factual call that was present in the East Wing. Of course, there was a very forceful dissent in Haverty looking at the facts of the Haverty case. In Haverty, the plaintiffs were in a unit that was designated as a general population unit, 360 beds. The department was trying to manage an overcrowded prison. Here, and it was a 3-4 decision. So the court held, well, qualified immunity for now, because it wasn't obvious. Here, this was a classic segregation unit, absolutely no doubt about it. 1 hour out, called segregation, 1 hour a day out of segregation. So under Longvale, constitutional violation, entitlement to damages.
Now, if you're right with regard to the 14 days being constitutional in nature, it would have to be under our state constitution, because Sandin versus Connor approved a 30-day period without process, correct?
Sandin, of course, each due process analysis is factually dependent on the facts of each case. Now, in this case, the Superior Court in Haverty, as well as the Superior Court here, did that type of factual analysis and found a Sandin violation here.
For the 10 months, but you're saying it kicks in at 14 days, and I guess in Sandin versus Connor, the 30 days there was not viewed to be an atypical and significant hardship, which triggered a liberty interest. So if the 14 days is constitutional, it seems to me it would have to be under the Massachusetts Constitution. Or are you saying that your 14-day constitutional limit is arguably federal in nature?
I'm saying that in each case, when you look at what the degree of process required and when, depends on the facts of the confinement in that case, the process available, and applying that analysis, the court found compliance with these regulations in Haverty, and in the Superior Court in this case found that compliance with these regulations was required by Sandin as a factual matter. And we believe that's correct, but we also believe it's unnecessary to reach that question because the constitutional nature of these regulations has already been affirmed by Haverty, which was long after Sandin, which was after Sandin. So that there's really no need to go to undertake that analysis, but we do believe it was well reasoned below.
All right, counsel, we'll have to leave it there. Thank you. We'll take a brief recess.
Thank you.